Welcome back. There are special provisions of Article 2 that apply only to merchants. Designation as a merchant or a non-merchant is important for Article 2 purposes because in some cases, special standards apply to merchants. Now, the general definition of a merchant is a person who regularly engages in the sale of goods of the kind that are involved in the contract. So, a person who is engaged in the buying and selling of goods of the type that the contract concerns is a merchant. A merchant could also be a person who utilizes the services of a merchant, or a person who is entrusted with the power of a merchant. But right now, focus on a merchant is a person or entity that regularly engages in the sale of goods of the type involved in the contract. Now, not every merchant is always a merchant. A merchant for one type of goods is not necessarily a merchant for another type. For instance, if you owned a shoe store and you sold shoes, you would be a merchant for the sale of shoes. The law would recognize you as a merchant. However, if you decided to sell the racks that hold your shoe to a third party, you are not in the business of selling fixtures. Therefore, you are not a merchant for that purpose, for that transaction. So you would be a merchant for the sale of shoes, but not a merchant for the sale of a rack on which to display shoes. In the case in your book, DeWeldon Limited versus McKean, this involves an artist who had lost the rights to his artwork, but the company that owned those rights allowed the artist to keep the artwork at his house. They did not make any effort to show that the artwork did not belong to Mr. DeWeldon, who was the name of the artist. And eventually, DeWeldon sold some of the artwork to third parties. Now, this artwork was not DeWeldon's to sell, right? And so the company, the finance company, attempts to recover those goods from a third party who has purchased the goods. Now, the UCC says that if I entrust goods to a merchant, I take on the risk that the merchant will sell those goods. Now, I have a claim against the merchant for selling goods that didn't belong to the merchant. However, I cannot recover the goods because of a provision relating to the buyer in the ordinary course of business. We'll talk a lot more about that. But in this case, the financing company was unable to obtain the painting back because Mr. DeWeldon was seen as a merchant. So I have entrusted these goods. Now, the UCC imputes a certain level of knowledge and awareness to merchants. And therefore, for merchants, the law can differ because there's less necessity for safeguards. Average household consumers buying goods for personal or family or household use may need additional protections that a business entity who is in the business of selling and buying goods, that party may not need those same protections as your average household consumer. Now, parties to a contract under the UCC must perform in good faith. Every contract or duty within the UCC imposes an obligation of good faith in its performance or enforcement. And we find this in Article 1 of the UCC. And the UCC defines good faith as honesty in fact in the conduct or transaction concerned, meaning you are being honest. The UCC places an obligation of good faith on every party to a contract. You must negotiate the contract in good faith. You must perform the contract in good faith, in an honest fashion. Merchants are subject to an additional good faith standard. Honesty in fact, yes, but also the observance of reasonable commercial standards of fair dealing. Meaning, what do other merchants in that field do? How do they perform? So in meeting your obligation of good faith, a merchant must not only be honest, but it must conform to the standards of reasonable commercial standards of fair dealing in the trade. So merchants have a higher good faith standard than non-merchants. Article 2A governs contracts for the lease of goods. Now there's a lengthy chapter in your book governing Article 2A. However, we're not going to focus much on Article 2A because most of the rules regarding the lease of goods are similar to the rules for the sale of goods. I do, however, want to make certain, bring attention to certain facts. Article 2A governs any transaction that creates a lease of goods as well as subleases of goods. So Article 2A defines a lease as the bargain between a lessor and a lessee. A lease is the transfer of the right to possess and use goods for a period of time in exchange for payment. Thus, a lease equals goods, tangible, movable items, for a term, meaning some time period, in exchange for consideration, something of value. So that's the definition of a lease. When you lease a new vehicle, for instance, the vehicle is a good. There is a term associated with your lease, 3-4 years, and you pay valuable consideration for the use of that item during that term. Now, the parties to a lease, this is sometimes confusing. A lessor is the one who sells the right of possession and use of goods under the lease. The lessee is the party that acquires the right to possession and use of goods under a lease. Lessor is the one who owns the goods but is transferring them for use by another over a certain time period. The lessee is the person who acquires the right to possession and use of those goods for that time. So in conclusion, what did we learn today? The UCC governs all the phases of an ordinary sale or lease of goods. Article 2 of the UCC governs contracts for the sale of goods, and Article 2A governs contracts for the lease of goods. That's it for this one. Thanks for listening. We'll see you soon.